proposed a criminal charge that NSD has not approved, but that case was prosecuted under a different statute and a conviction obtained. So I think we have made great progress towards educating our field on the importance of these cases and the need to bring them.
Thank you. Now to Mr. Horowitz. Have the Justice Department and the FBI adequately addressed how FARA fits into the department's overall national security efforts? If so, explain, and if not, please explain what else must be done.
Well, we have not closed our recommendation regarding the need for a comprehensive strategy. We're looking forward to the August update that we are due from NSD about that. And our review highlighted this disconnect and the lack of a comprehensive strategy, both based on our discussions with assistant U.S. attorneys, FBI agents handling these cases, as well as the National Security Division folks, because not only were there the disagreements about the number of cases and what classification they fell in and which were FARA cases and which were not, but the absence of prosecutions and the absence of records to see what had happened with reviews that we heard complaints about.
Mr. Hickey, leading into your next two questions, I'm going to ask you, the department recently required the Podesta Group and Mercury LLC to register for engaging in public relations campaigns to benefit a foreign government. Public reports show that a foreign-controlled company hired Fusion GPS and Glenn Simpson to do propaganda work in an effort to repeal the Magnitsky Act. Fusion GPS reportedly dug up dirt on Mr. Browder's property and finances and helped generate negative news about him and his company. This covert negative publicity campaign would principally benefit the Russian government. So without reference to that particular case, if a company engages in a publicity campaign on behalf of a foreign government to influence U.S. law, does that generally create an obligation to register under FARA?
I'll get the hang of it. Thank you, Senator, for the question, and thank you also for acknowledging my inability to comment on particular investigations or potential investigations today. Let me describe our practice. Where we see credible information to believe that someone is acting as an agent of a foreign principal, we face a choice at that moment. In most cases, we don't have indications of willfulness, meaning we don't have indications that the individual is deliberately choosing not to register but aware of their obligation. And in that case, we would send a letter of inquiry and solicit more information. However, if we had indications that the agent was acting willfully, it may be more appropriate to go directly to a criminal investigation. I think in your question, sir, you used the terms "on behalf of." I think I want to be precise. The statute applies to agents, so those who are working at the direction or control of a foreign principal. One of the challenges we sometimes face is that independent groups may have interests that overlap with or coincide with foreign governments, and that can be a challenge to our determination that they are acting at the direction or control of the foreign principal.
Senator Feinstein.
Thanks very much, Mr. Chairman. Mr. Horowitz, you've always been a straight shooter, and that's very much appreciated. I've been reading your remarks, bottom of page 3 and top of page 4, where you have a number of recommendations.
Yes.
And you begin by saying NSD officials told us they have difficulty compelling the production of information from persons who may be agents, and therefore NSD was pursuing civil investigative demand authority from Congress excuse me, to help enhance the NSD's ability to assess the need for potential agents to register. And you go on and you talk about including controls and oversight, and you also speak about ensuring the statutory 48-hour time limit for agent filing of informational materials. I think it's pretty clear that we need some legislation in this area. Would you be prepared to work with us on a bipartisan basis to strengthen this?
Absolutely. And I think my folks who did the audit have a fair amount of understanding now about where some of the fault lines are here.
Could you just sort of prioritize, if you were us, where you would go first, second, and third?
I think first and foremost is what you and the chairman have identified, which is putting some teeth into the statute and making sure that the FBI, the National Security Division, and AUSAs around the country believe they have the tools to ensure that people voluntarily comply. It shouldn't be the case that you're found about through Google searches or otherwise, told to register, and then you register. If there are no consequences to registering, why not wait for the knock on the door rather than come up voluntarily and do it? So I think that's first and foremost. Second, obviously, to do that, prosecutors and agents need to be able to get the information to see who isn't voluntarily complying. And that's where the civil investigative demand comes in. And I think then third, it's the question that has been raised and we talk about in our audit about the impact of the Lobbying Disclosure Act. What we heard over and over again was that the exemption in FARA for folks who are complying with the Lobbying Disclosure Act has impacted and is a major reason why there's been a substantial drop over the last 2 decades in the number of filings. The problem that we had when we went in to see if that was true is that the department wasn't tracking information and didn't know, in fact, if that was true. It was a supposition, but it wasn't, there weren't records to show it. So I would suggest those are the 3 areas where we should first and foremost focus.
Just to comment, I don't know a time when the United States feels more invaded. And by this I mean 21 states' election systems were pierced in this last election, we believe, by Russia. And that's a pretty sovereign interference, an interference with our sovereignty. So there are 2 of us here that serve on the Intelligence Committee, so we know some of these things. And it seems to me that the time has really come to tighten this act up, to know who's in the country, to see that they formally apply, to see that if they violate, it's prosecuted, and that it has become a priority for us. Would you agree with that?
Absolutely.
Gentlemen, do you have a comment to make on what I just said?
Senator, thank you for asking what other tools we might require. I'm aware of at least 2 proposals, I think, one that may have been introduced for legislative changes, and we are working hard to coordinate views across the administration on those proposals, and I, too, in the department look forward to working with Congress on this important question.
Well, can you give us the name of the legislation so we can find it?
I know that Senator Shaheen has introduced one bill.
Okay.
There is another bill in the House. To be candid, I'm not sure if it has been introduced publicly, so I don't want to exceed my writ today, and I've heard talk of other potential bills, but I know of 2 that we're working on right now.
Thank you, and we'll talk with Mr. Horowitz and you. Thank you, Mr. Chairman.
Senator Hatch.
Well, welcome to the committee. We're happy to have all of you here, and I come to this hearing with one simple message. Let's be fair. Let's judge both sides of the political divide, both parties, by the same standards. And there are a few things that I take more seriously than the allegations of foreign interference in the 2016 election. Actually, for foreign influence, or actually foreign influence would be an egregious violation of our sovereignty. Even the plausible allegation of it can, if left unaddressed, seriously undermine public confidence in our institutions. Now, we've heard some pretty serious accusations of foreign influence over the Trump campaign, for instance, whether here in the Senate or in the media. And frankly, many of these allegations have been truly outlandish. Most have been politically motivated, and all have been taking their toll. Even the most outrageous accusation, repeated often enough, will slowly acquire a false ring of truth, especially in today's media environment. And so to the extent there is anything to these allegations, Republicans are stepping up. There are investigations underway by both the House and the Senate Intelligence Committees. Before the appointment of special counsel by the Department of Justice, the House Oversight Committee was investigating. And now the Senate Judiciary Committee is investigating. All are controlled by Republicans. So I don't want to hear anyone complain that we aren't standing up and doing what is necessary here to get to the bottom of these things. As to today's hearing, a critical part of the investigation in this committee will be the application of the Foreign Agents Registration Act. It's a critical part of the equation. I want to commend Chairman Grassley and the ranking member as well for holding this hearing and leading the way on this. but I also want everyone, the media, the Democrats, our constituents, and Republicans to hear me and to hear me clearly. While these allegations may be too serious to ignore, they are also too serious to be left incomplete and too serious to be used for partisan ends. If we're going to get to the bottom of this, we need to investigate the whole story. That means looking at more than just foreign influence over the Trump campaign. It includes looking at serious allegations of foreign influence over the Clinton campaign and the Democratic National Committee as well. After all, if this national controversy is going to be brought to any legitimate conclusion, we have to treat it as more than just fodder for partisan gamesmanship and more than a headline-grabbing attack on the president. We need to explore both sides of the story. According to the committee staff report, and as numerous reports in the media have revealed, there are serious questions about whether foreign actors wanted to hurt, not help, the Trump campaign. And there are serious questions about whether foreign actors wanted to help, not hurt, the Clinton campaign. Many suspect that foreign actors wanted to help neither campaign, but they wanted to hurt our electoral process as a whole by sowing chaos and confusion. And so there are questions this committee needs answered. I'm pleased that the Trump campaign individuals have agreed to be interviewed, but it doesn't end with them. Fusion GPS, for instance, the opposition research firm, has a lot of questions to answer. The Democrat National Committee has questions to answer. And the Clinton campaign has questions to answer. So in conclusion, we have heard Democrats level grave, often outlandish accusations at the Trump administration and family. We've seen the media pursue it relentlessly, but we've heard far less about the rest of the story. Now, Mr. Chairman, I applaud you and the ranking member for scheduling this hearing. And I implore my Democratic colleagues in the media to join me to join the Judiciary Committee in getting to the bottom of this. We must ensure that these investigations serve as an opportunity to protect our institutions, not merely as an excuse to attack our political opponents. Our constituents deserve better than they've gotten. And we can start by fixing this today and doing what really ought to be done in this particular area. So I want to thank you three gentlemen for appearing and the other witnesses as well, and just say that I hope that we can be fair in these matters and treat the Trump administration just as fairly as we want our personal interests to be treated. Thank you, Mr. Chairman.
Thank you, Senator Hatch. I appreciate your remarks. Senator Whitehouse.
Thank you, Chairman. Gentlemen, welcome. I will try to move through my material quickly to obey the Chairman's injunction that we move along. First, do any of you have any doubt whatsoever that Russia interfered in our 2016 presidential election? None. Okay. Just to be clear.
Well, let me just say, I only know what I've read in the newspaper. I'm not involved. We're not involved.
Understand. It's not because you're the IG.
Yeah.
So the Foreign Agent Registration Act, you will all agree, I hope, has as its purpose to identify foreign agents seeking to influence U.S. government policies, correct? Correct, yes. Correct. Is that an important purpose? How important a purpose, in very brief words?
Very important, Senator.
Agreed. Agree.
Can foreign agents seeking to influence U.S. government policies use shell corporations to obscure their identities?
Senator, I can certainly conceive of situations where agents acting here for a foreign principal could use corporate forms or other measures to hide the connection to the principal.
And the use of non-transparent corporate forms, does that help or hinder your ability to investigate foreign influence in U.S. government policies?
It would be part of the challenge I referred to earlier, Senator, of the difficulty in proving direction or control to the ultimate principal.
So greater transparency as to who is behind a shell corporation would be an advantage to law enforcement.
I think so, Senator, yes.
Similarly, could foreign agents use anonymous political contributions, say through 501c4s or through identity laundering devices like Donors Trust, to obscure who is actually making the political contribution?
Senator, I'm not so much an expert in campaign finance or contributions. What you've said sounds right to me, but I don't want to mislead you that I have any particular expertise in
Let's
that
put it
area.
this way. If your purpose is to identify foreign influence being brought to bear on our government, and election money is pouring in, and you don't know who is actually behind it, that creates an avenue for foreign influence to influence our government, correct?
That sounds right to me, Senator.
Can business relationships be used, and indeed is it not well established that Russia tries to use business relationships to facilitate or as cover for foreign influence operations?
I'll defer to the FBI to speak to Russia specifically. I know that one of the challenges, Senator, that we face is that there's often an economic or commercial cast to the activity here, but in fact, the foreign government may be the principal beneficiary, or the activity may not be private or non-political in nature, and thus require registration.
And it's established through both the Kremlin Handbook report by CSIS and the Kremlin Trojan Horses report by Atlantic Council that Russia actually uses business relationships to corrupt and to influence people in other countries where they're seeking influence, correct? Mr. Priestap, you're familiar with that?
I'm familiar with both reports, and in my experience, that is true.
So, in an investigation into a foreign agent's efforts to influence U.S. policy, being able to understand business relationships could be vital to understanding the influence scheme, correct?
Absolutely.
And in that effort, are an individual's tax returns potentially very significant, indeed often obvious, investigative material?
A variety of financial records pertaining to any of the individuals or entities involved could be of importance, but
including tax returns.
Including tax returns.
Which are so widely pursued in criminal investigations. There's actually a whole section on the U.S. Attorney's Manual devoted to the simple process for investigators getting access to tax returns, correct?
Yes, I'm not an expert on tax returns, but they can be of investigative value.
Thank you very much. My time has expired.
Senator Cornyn and then Senator Klobuchar.
Thank you, Mr. Chairman, for holding this very important hearing, and I hope some of our Democratic colleagues have objected to the continuation of this hearing beyond 2 hours will reconsider and withdraw that objection, because what we're doing here is simply too important to the security of our country. Mr. Priestap, thank you for making what I think is a really important point. We tend to focus on the trees instead of the forest. And here, of course, the immediate concern is about Russian involvement in our elections. But you've made the point, I believe, that that our international adversaries will use a range of activities, both overt and covert, to undermine us in a variety of ways. And of course, now we're just talking about the Foreign Agents Registration Act, which would be more of an overt means of doing so. But I fear that FARA violations are happening around this town all the time, meaning foreign governments are attempting to exert undisclosed influence over U.S. policy, and we simply don't know about it. I experienced this recently in my work on the Justice Against Sponsors of Terrorism Act, which is a law that gave Americans tools to fight terrorism and bring justice to victims that had the overwhelming support of Congress, notwithstanding the veto of President Obama. Opponents of the bill warned that any number of consequences would occur with our relationship to Saudi Arabia, which was not named in the bill, but of course none of those have resulted.
But even though they were wrong, the debate was a real one and the kind that ought to accompany any bill. But along with healthy debate, the Kingdom of Saudi Arabia reportedly undertook a cloaked campaign to gut the legislation. It involved ghost-written letters and ghost-written legislation, involved threats to American companies. It involved, as of October 2016, Saudi Arabia paying American lobbyists and public relations firms to undermine or overturn the legislation. They paid them $1.3 million each month to fight against the right of American victims of terrorism to sue terror financing nations. But the worst part of this campaign was the use of veterans to persuade members of Congress. According to press reports, agents of the Saudi government recruited American veterans, flew them to Washington, wined them and dined them, and then put them up in fancy hotels and provided them with false information to provide to members of Congress. They didn't tell these American heroes that who was sponsoring them and who they were serving. And not only did these agents apparently violate FARA, they put our American veterans at legal risk. Veterans indicated the organizers concealed the sponsorship of the
in fact be just a well-connected corporate enterprise, not under the direction or control of a foreign government, but whose interests overlap and who, under our regs, are doing work, the principal beneficiary for whom is the foreign government. Those folks are still obligated to register. So we search the LDA database and try to find those potential registrants and ferret out whether the principal beneficiary is really the government or political party. But it's a challenge for us, sir. Thank you.
Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you to you and Senator Feinstein for this hearing. And while it's disappointing that some of our witnesses aren't here today, it is important to move forward in a bipartisan way. And I'm going to focus on the issues at hand here. Mr. Hickey, I am a co-sponsor of bipartisan legislation, the Foreign Agents Registration, Modernization, and Enforcement Act, to give federal prosecutors the civil investigative demand authority they need to investigate foreign entities and help ensure that they comply with the law. Under the bill, the Justice Department could make suspected FARA violators turn over relevant documents before initiating a civil or criminal proceeding. And I understand that obtaining this authority has been a priority for the Justice Department's National Security Division. Can you explain why this type of authority would be so helpful to prosecutors?
Thank you, Senator. As I mentioned earlier, I'm not in a position to call for any particular legislative change today. I simply don't have authorization to do that. But as I think you've noted, twice in the past, I think in 1991 and about 1998, the federal government has proposed CID authority for NSD for exactly that purpose. And so while I won't advocate one way or the other today, I'll simply point out that that authority would create a middle ground between resorting to a criminal subpoena, which you wouldn't necessarily have the basis to do or be in the right position to do, and the voluntary letter of inquiry that we rely heavily on now.
Okay, thank you. And then a more detailed question on Russian TV. We know our intelligence agencies have found that Russia tried to interfere in our election. In January, the Office of the Director of National Intelligence released a report documenting some of the ways they tried to do this, including through news outlets. And they say that RT America was explicitly set up to avoid the Foreign Agents Registration Act because it's registered as a nonprofit instead of a government affiliate. Can one of you, Mr. Hickey, Mr. Priestep, can you elaborate on why RT is not currently registered under FARA?
Senator, I probably shouldn't comment on any particular individuals or entities, but it strikes me that when Congress passed FARA or amended it recently, maybe in the 60s, this is when this changed, or the 40s, it deliberately carved out U.S.-owned media organizations. It was very precise about that. So what that tells me as a prosecutor is that that intended to capture potentially others who are not U.S.-owned.
Or not.
So I'm familiar with the reporting you've referred to, and I'm familiar with that provision of the statute.
Very good. Well, it would be good if we could pursue that line if, in fact, the statute says that they've carved out U.S.-owned from foreign-owned, and obviously it might not just be Russia, it could be another government as well. Do you think, this is just to the panel, whoever wants to take this one, do you think that the FARA requirements in current law adequately reflect recent technological advances, or would additional requirements such as clarifying FARA social media disclosure standards and updating the 48-hour rule for Facebook and Twitter help the FARA unit do its work more effectively? I know you can't comment on exact legislation, but are there tools that could be out there that could be helpful to you?
Thank you, Senator. I think the internet does present a challenge for us because the statute is limited to individuals acting within the United States. I know as early as 1940, the Attorney General, then Attorney General, issued an opinion that if you mail materials into the United States, even if you're not here, you're acting within the United States. So I see the challenge with the internet as both a technical one, but also a question of jurisdiction. Even if you're, quote unquote, subject to FARA because you're acting here, how will we reach the agent who is physically located in another country? I see that as a significant challenge.
Okay. Do you want to add anything, Mr. Priestep, for any of my questions?
No, I just think Mr. Hickey's exactly right, and that is the true challenge, and I'm not certain how you legislate that.
Okay. Anything, Mr. Horwath?
No, I think the internet presents some new challenges, and thinking that has to occur on the 48-hour rule and other requirements.
Mm-hmm. It just seems like we may need to update this law in light of everything that we've seen, given that another election is around the corner and everyone in America wants to have their vote count, and that means not having influence from other entities. So I want to thank you very much.
Thank you, Senator Klobuchar. Now, Senator Lindsey Graham.
Thank you, Mr. Chairman. I'd like to add my compliments to you and the ranking member for conducting a very organized way forward in terms of dealing with the threats we face as a nation and changing our laws consistent with those threats. I am too disappointed that we have a 2-hour rule on something that's important. 2 hearings I know of have been canceled because we can't agree on health care, but we should be able to agree this is important. Mr. Browder's got a lot to say. So here's the deal. AIPAC, are you familiar with AIPAC? American Israeli Political Action Committee.
I have heard of it, sir, yes.
Okay. They come up here in droves, lobbying Congress to do things, in their view, good for the U.S.-Israel relationship. I know they have a lot of contacts in Israel. Should somebody like that be a foreign agent?
Sir, it's probably not appropriate for me to comment on a particular entity, but I think you've hit on something very important to us, which is right now we rely principally on public reports for the basis to send voluntary letters of inquiry. I would love to receive more information in whatever form anyone can give it to me about what's occurring behind closed doors so we are able to take steps to investigate if appropriate.
I'm not suggesting AIPAC's doing anything wrong, quite the contrary. They're a group of Americans who've banded together to maximize their influence to speak about something important to them that involves a foreign ally. So I think the AIPAC model is a good thing, and that's not my concern because they're very transparent. They have conventions, and we all know how the game's played there. So I just want to make sure that lobbying on behalf of a foreign government or a U.S. relationship with a foreign government is not a bad thing as long as you do it right. And I have some friends of mine who represent foreign countries that come into my office all the time talking about the country's view of whatever we're doing. Nothing wrong with that as long as you're up front. An example of what would bother me, General Flynn, who I admire his service to our country, but he wrote an op-ed piece saying that we should extradite Mr. Golan, the guy that Erdogan hates so much. I didn't know at the time that he was receiving hundreds of thousands of dollars from a group that was representing Turkey. That's the kind of thing we want to get a hold of. Is that correct, Mr. Hickey?
We did advise General Flynn that we believed he had a registration obligation, sir.
Okay, but that kind of conduct is what we're all worried about.
Or may have, I should say.
May have. So let's get back to what Senator Klobuchar was talking about. You've got Russian bots that are actively pushing fake news and news helpful to one candidate, harmful to the others into our political system. So you got all these Russians sitting around making up crap and sending bad articles to key districts to influence outcomes of an election. This time it may be against the Democratic Party. Next time it may be against the Republican Party. Next week it could be Iran or North Korea. It goes on and on. What happens, or what power do we have, if somebody in the United States coordinates with them? Some platform or website begins to coordinate with content that originates outside the country, being disseminated in a political fashion within the country. If somebody coordinates with them or becomes an ally, what status would they have?
Senator, I'd have to look at all the facts and circumstances of a particular case. FARA reaches conduct when the person acting within the United States is doing so under the direction or control or as the agent of the principal.
What, in this circumstance, the generated content is coming outside the country, it's being delivered in the country for a political purpose, and any American or organization within the country that colludes with them, for lack of a better word, should we have laws that deal with that?
Under FARA, I think one question you'd have to ask, Senator, is whether that person here is acting as the agent or under the direction or control of those foreign individuals.
If they are, should they register?
That's one of the principal pillars of FILA, is that if you're an agent acting under the direction or control.
Do our laws give a good enough answer to my question, or should we change our laws to deal with what's the reality of the future?
Senator, I don't feel prepared to answer that question today. I'm sorry.
Thank you.
Senator Franken and then Senator Kennedy.
Thank you, Mr. Chairman. Thank you, gentlemen, for testifying. In January, the Director of National Intelligence released a classified report detailing interference in last year's election. The report states unequivocally, quote, Russian President Vladimir Putin ordered an influence campaign in 2016 aimed at the U.S. presidential election. Mr. Hickey and Mr. Priestap, you're here today representing the Justice Department's National Security Division and the FBI's Counterintelligence Division. Have you read the declassified intelligence assessment of the Russian operation?
I have, Senator.
Thank you.
I have as well.
Good. Have either of you read the classified version of the report?
I have.
Okay, thank you.
I'm not sure, sir.
Okay. Do you have any reason to doubt the intelligence community's assessment that the Russians interfered in last year's presidential election?
No, sir.
No, sir.
Well, for some reason, President Trump remains unwilling to accept the fact that Russia interfered in our election. We saw this during the campaign when he dismissed reports of Russian meddling by suggesting that the hacking could have been carried out by, quote, somebody sitting on their bed that weighs 400 pounds. But now, 6 months into his presidency, we continue to see that reluctance to acknowledge the truth. Just last week, the newly minted White House Communications Director, Anthony Scaramucci, appeared on CNN. He said this, quote, you know, somebody said to me yesterday, I won't tell you who, that if the Russians actually hacked this situation and spilled out those emails, you would never have seen it. You would have never had any evidence of them, meaning that they're super confident in their deception skills and hacking. The host of the show asked just who that somebody was, and Mr. Scaramucci admitted that it was President Trump, who had explained that if the Russians had, quote, hacked the situation, that the United States would not have evidence of that hacking because of the Russian superior intelligence capabilities. Do either of you know where President Trump got that idea?
No, sir.
No, sir.
Well, I'll tell you. President Trump believes that to be true because Vladimir Putin told him so. The New York Times later confirmed that Putin was the source of that information. The Times reported that President Trump emerged from his meeting with Putin to, quote, tell his aides that the Russian president had offered that Moscow's cyber operators are so good at covert computer network operations that if they had dipped into the DNC systems, they would not have been caught, unquote. Now let that sink in for a moment. The President of the United States is taking the word of Vladimir Putin over that of our nation's intelligence agencies, which demonstrates a stunning lack of confidence in the men and women who put their lives on the line to keep us safe. And the President of the United States then goes on to repeat that Russian lie to the American press and to Mr. Scaramucci, effectively spreading Russia's misinformation for them. Mr. Priestap, you have experience in counterintelligence. When then FBI Director Comey appeared before the House Intelligence Committee in March, he described the Russian operation as, quote, unusually loud. He said, quote, it's almost as if they didn't care that we knew. Their loudness, in a way, would be counting on us to amplify it by telling the American people what we saw and freaking people out about how the Russians might be undermining our elections successfully, unquote. Do you agree with former Director Comey's assessment? Was the Russian operation unusually loud?
Yes.
Mr. Hickey, you manage the National Security Division's efforts to fight cyber attacks. Do you agree with Director Comey's assessment, former Director Comey's assessment?
In my position as a lawyer, sir, I would defer to Director Comey on that question and the FBI.
Let me just, can I have a few seconds? So it seems fair to say that not only did Russia interfere in last year's election, but that Russia likely wasn't trying to fly under the radar. Contrary to what Putin may have told President Trump, it would seem that Russia actually wanted Americans to find out about its efforts, that our knowledge of their operation and the unease it continues to cause us was in fact central to undermining Americans' faith in democracy. Thank you for your indulgence,
Okay.
Mr. Chairman.
Senator Kennedy.
Mr. Chairman, are we going to get to Mr. Browder today?
We will we'll stop here at 11:30 as the rule requires, and then Mr. Browder will be here tomorrow at 9 o'clock.
Okay.
We'll recess the hearing till 9 o'clock tomorrow.
Okay. And that's because of the 2-hour rule?
Yes.
I'd like to join Senator Graham and Senator Cornyn. I'd like to know who invoked the 2-hour rule. Certainly they're right, but I think they owe it to this committee and to these witnesses, some of whom traveled a long distance to explain their reasoning.
Yeah, and he came from overseas to be here.
And has to stay now an extra day.
He's willing to stay. And I don't know why the 2-hour rule was invoked, but if it was invoked so we couldn't talk to Mr. Browder, it can happen tomorrow at 9 o'clock. So we can overcome if that's the rationale.
Well, if Mr. Browder's here, I apologize for that.
I think he will be in the ante room if you want to apologize.
Okay, I will do that.
Yeah.
Mr. Hickey, according to media reports, Mr. Sidney Blumenthal lobbied former Secretary Clinton to show support. He was asking Secretary Clinton to show support for a prime minister candidate in the country of Georgia. According to media reports, Mr. Blumenthal allegedly passed along personal letters to Secretary Clinton from the leader of the opposition party and transmitted a memo, allegedly, to her from an acquaintance by the name of Mr. John Kornblum. The letter urged Secretary Clinton to support the same opposition party in the Georgian elections. According to media reports, and I guess you could check as a matter of fact, neither Mr. Blumenthal nor Mr. Kornblum have registered under FARA. And I'd like to know why DOJ has not required them to register.
Thank you, Senator. Unfortunately, consistent with longstanding Department of Justice policy, I can't confirm or deny or comment on particular individuals or entities or investigations or potential investigations.
Okay. You ever heard of a group called Fusion GPS?
I have, sir.
I think its co-founder is Mr. Glenn Simpson.
I have seen that in media reports, sir.
Has he registered under the statute, FARA?
I have not searched for his name, sir, so sitting here today, I don't know for sure. I think the answer is no, but again, I'm not sure. It's public.
Well, has anybody at the Department of Justice searched for his name?
I don't know that, sir.
Is somebody looking into that?
I can't comment on that, sir.
General Horowitz, why, I think you testified that 2 decades ago, enforcement of FARA became less of a priority. Why was that?
Well, what we saw was about two decades ago a significant drop-off in the number of filings. And one event was the 1995 Lobbying Disclosure Act, but actually preceding that by 2 years was the imposition of fees for filing. And if you actually look at our report and the chart we've done and the graphic that we've included in the report, it shows the cliff actually starts occurring in 1993 after fees were imposed. And one of the challenges we had when we went in and did our audit was trying to determine what was the impact of the Lobbying Disclosure Act. And the problem we had was there really had never been an assessment done by the department and the folks administering the program to determine if that was in fact the cause, as opposed to a
What do you think?
supposition.
You've studied this issue, General. What do you think the cause was?
It looks to be a combination of both, potentially, as well as we talked about earlier, the need to have a strong enforcement policy and a mechanism to ensure that folks out there understand there are real consequences to failing to register. And I think one of the concerns our team had and I had in looking at this is in 50 years doing 7 criminal cases, 5 of which result in convictions and 3 of which involve FARA charges over a 50-year period, doesn't necessarily send the message out there that there's real teeth behind the statute.
Well, I'd like you to think about this, too, to let it sink in, all 3 of you. What you allow is what's going to continue.
Okay.
Now, I understand that the Justice Department can't talk about investigations, and I respect that, and I think it's a good rule. But General, I hope that you will continue to monitor this, because it's clear that there's been a failing, and I don't know what metric we have to understand whether it's been fixed.
Yep. No. We will do that.
Thank you, Mr. Chairman.
Senator Hirono, if you use your 5 minutes, then I got to inform Senator Cruz you might only have 2 or 3 minutes for you, and then we'll 2-hour rule we have to turn. Senator Hirono.
Thank you, Mr. Chairman. Mr. Hickey, despite conducting significant lobbying on behalf of foreign pro-Russian interests, Donald Trump's former National Security Advisor, Michael Flynn, and former campaign manager, Paul Manafort, only filed with FARA after their activities were publicly disclosed. Doesn't that undermine the purpose of FARA?
Good morning, Senator. Unfortunately, I can't comment on particular cases. What I will say is we do our level best to identify conduct through every source we can and act on it by sending either a voluntary letter of inquiry or opening a criminal case.
So regardless of whether you can comment on particulars, I'm getting to the delay in registering under FARA, and I'm wondering whether a delay in registering at some point can amount to a willful violation of FARA.
I think that's a good question, Senator. The statute makes clear that if you register late, that does not preclude a prosecution, and there may be a number of facts that raise an inference of willfulness. Yeah. Certainly, the goal of the statute is to ensure that that agents register immediately, essentially, upon becoming agents of principals, or I think it's within 10 days. That is what the statute demands.
So perhaps we need to strengthen that part of the law, because I think at some point you mentioned that there needs to be a showing of willfulness and to show a violation of FARA. And I would say that substantively, at some point, a delay in registration amounts to a willful violation. Further question. During the 2016 Republican convention, the Trump campaign insisted on a change to the National Republican platform, making U.S. policy on Ukraine much more favorable to the Russian government. At that time, Paul Manafort was the Trump campaign chair, and at that time he had been paid $17.1 million in unreported payments from the Party of Regions, the pro-Russia party in Ukraine. He had also had extensive business dealings in the Ukraine and with wealthy Russian oligarchs, yet he did not register under FARA until this year and never disclosed this work. Wasn't this the kind of activity on behalf of a foreign government that FARA registration is meant to disclose?
I'm sorry, Senator, I don't think I can answer that question. We had previously advised Mr. Manafort we believed he had an obligation to register, and he is registered.
I think that answers my question. Would this raise any red flags for you or your investigators, Mr. Priestap?
I'm sorry, I can't comment on that.
You can't even comment on whether